Hi, good morning. This is a Bombay High Court judgment. Citation is Armstrong Machine Builders Private Limited versus State of Maharashtra. Act is Maharashtra Stamp Act. Interesting question was, in the absence of provision which grants power to the authority to condone the delay while seeking refund, or section does not say delay cannot be condoned by the authority. So one is there is no provision to condone the delay. Second is section also does not say the delay cannot be condoned. Third is the act does not exclude section 5 of the limitation act, sufficient cause. So is the litigant remediless? That is the question before the Bombay High Court. Facts: Armstrong Machine Builders Private Limited. Hereafter AMB. I will say AMB because the name is lengthy. Then DMAT Holdings, I will say DM. So AMB entered into a share purchase agreement with DMAT Holdings UK Limited, that is DM. Under the Stamp Act, AMB paid stamp duty of approximately 1.20 crores. There was a press note from the Ministry of Commerce saying that a non-resident entity of a country could invest in India only under the government route, which required prior approval of government. So the UK company DM applied for approval for acquisition of shares of AMB. Ministry of Commerce rejected it, rendering the share purchase agreement void ab initio and unenforceable. So AMB applied for refund of stamp duty. The authority rejected it on the ground of limitation. The limitation for applying refund of stamp duty was 6 months from the payment of duty. So on rejection, AMB filed a writ petition before Bombay High Court. High Court noted the following facts. July 21, petitioner paid, that is AMB paid stamp duty. The rejection of the government approval came in 24/3/2022. Then 22/9/2022 refund application was filed. So the refund application was rejected on the ground of delay of 1 year and 2 months. I have already said that within 6 months you have to ask for refund. Otherwise you are not entitled. Court noted that the Ministry of Commerce rejected the application for approval only on 24/3/2022. That is after 8 months of payment of stamp duty. Hence, refund application could not have been made within 6 months. It was only after the rejection the share purchase agreement became infructuous and the delay was beyond the control of AMB. Bombay High Court relied on the decision of Supreme Court in Mool Chandra judgment, wherein Supreme Court held that it is not the length of delay but the cause of delay which needs to be examined for seeing the sufficient cause. Length is not important, but the cause. Further, Supreme Court held in Banu Sayyid Prasad Parvat case, if the state is satisfied that the case of citizen is a just one, even though legal defenses may be open to the state, it must act like a honest person. So if the state sees that even though it has a case on merits, on legally, legal defenses are available to it, but if the case of the citizen is a just one, then it must act like an honest person. That is what the Supreme Court said. The court, after going through section 47 and 48 of the Maharashtra Stamp Act, said, though the Act provided for an outer limit of 6 months to make the application, it does not say that application made beyond the period will not be entertained. So, on that part, it is silent. There is no provision conferring power of condonation on the authority, or any provision which states that the power of condonation cannot be exercised beyond that period. After 60 days, you cannot exercise. If you see GST Act and other acts, they will say they will give you a period of time for filing the appeal. After that, they will say delay condonation period, and then after that, they will say no, no. After that, there is no power to condone the delay. So there is no such provision. Then there is no provision which excludes applicability of Section 5 of the Limitation Act also. That is what the court noted. So the question before the court was, in such a circumstance, is the litigant remediless? Court said, in the present case, share purchase agreement became void and unenforceable after the rejection of application by Ministry of Commerce, which was beyond the control of AMB. Already we have seen the Ministry of Commerce, when it rejected the application, by that time 8 months was over. AMB paid stamp duty for a transaction that did not materialize. Refund must be assessed based on statutory entitlement and not defeated by procedural technicalities. The state, under the pretext of adhering to the period of limitation, it cannot unjustly enrich itself by forfeiting the stamp duty. A litigant cannot be penalized for the time consumed by the government authority. To deny refund in this case, the court said it will offend equity, justice, and fairness. On that ground, Bombay High Court ordered refund of the entire stamp duty paid by AMP. Thank you very much. Have a great and wonderful day.